Dear students, Namaskar. I am resuming to Article 19 of the Constitution, which talks about the various six freedoms under Article 19, Clause 1, Clause A. And also, these rights are subject to reasonable restrictions under Article 19, Clause 2 to 6. I am going to discuss one landmark judgment which was delivered by the Supreme Court. It was the case of Communist Party of India, Marxist versus Bharat Kumar and others. In this case, what was the issue? Issue was related to the demonstration or picketing are to be protected under Article 19, Clause 1, Clause A, provided they are not violent and disorderly. Means that they, on one hand, it was the petitioner which had organized or called for organization of Bandh, which was to be issued, whether it falls under the ambit of Article 19, Clause 1, Clause A, or it doesn't fall. So, the issue for calling for and holding Bandh is illegal or unconstitutional or to be protected under the fundamental rights under Article 19, Clause 1, Clause A. And this case, which was filed by one Bharat Kumar in Kerala, in the light of that the Communist Party of India, Marxist, had called for organization a Bandh in the pretense of right to speech and freedom under Article 19, Clause 1, Clause A. And the petition was filed, writ petition was filed by the petitioner under 226 of the Indian Constitution before Kerala High Court, and the Kerala High Court observed that no political party has right to call for Bandh on the ground that it is a part of fundamental rights of freedom of speech and expression under Article 19, Clause 1, Clause A. Nothing stands in the way of political parties calling for a general strike or hartal accompanied by express or implied threat of violence to enforce it. The call for a Bandh implies a threat to the citizens that any failure of his part to honor the call would result in either injury to a person or property, and involves preventing a citizens by instilling into him the psychological fear that if he defies the call or Bandh, he will be dealt by those who are allegedly supporter of Bandh, when a citizen is forced or threatened into profession of carrying on his business, there is a involved violation of fundamental rights at the instance of another. So no political party or organization can claim that it is entitled to paralyze the industry and commerce in entire state or nation, and is entitled to prevent the citizen not in sympathy with its viewpoint, so from exercising their fundamental rights or from performing their duties for benefit of the state. Because as and when any political parties are going to call for bandh, then it is always created one kind of apprehension in the mind of the citizens, either it's the community of students, community of businessmen, community of workers, or community of employees, or government employees or the private employees, that they will feel, in case if they won't support the bandh called by the political parties, then they will have to face the consequences of the music of punishments or music of threats or evil consequences, which may be imposed by the supporters of all those political parties which have called for bandh. So once this calling for bandh initiated by political parties, CPI, Communist Party of India, Marxists, and was declared illegal and unconstitutional, then the appeal was made to the Supreme Court by the Communist Party of India, and here the Supreme Court examined and evaluated the verdict delivered by the Kerala High Courts. And the Supreme Court held that court has ample jurisdiction to grant declaratory relief to the petitioner. In this case, as the case of petitioner is based on violation of their fundamental rights, the state has not taken any step to control and regulate the bandh, so it has a sufficient jurisdiction to declare calling of bandh and holding of it as a unconstitutional, especially because bandhs are not in the interest of the nation, but tend to regard the progress of the nation by leading to the national loss of production. The court cannot also ignore the destruction of the public and private properties when bandh is enforced by the political parties and other organizations. So the political parties and the organization which call for such bandhs and enforce them are really liable to compensate the government and the public and private citizens for the loss suffered by them. For such destruction, the state cannot shirk its responsibility of taking steps to recouping the loss from the sponsors and organizers of such bandh. So that's why the Supreme Court upheld the Kerala High Court's judgments, and you know that the Supreme Court had put its stamp on the decision of Kerala High Courts and uphold the decision of Kerala High Courts, saying so that these kind of bandh which are going to be called by the political parties are totally illegal and unconstitutional in the light of reasonable restrictions under public order, because it is going to create a disorder for the society and which could become a tool for the restrictions of public and private properties, and also going to violate the fundamental rights of others under Article 19, Clause 1, Clause A, the freedom of speech and expression, because any political party is not going to be provided license to breach the peace and tranquility, to violate the fundamental rights of others under Article 19, Clause 1, Clause G, which are supposed to carry their business, which are supposed to perform their duties, because they are also having equal rights under Article 19, Clause 1, Clause G, and you know that it's the paramount duty of the state to maintain the law and order and to maintain the public order, to maintain the peace and tranquility in the state. So it is a very good decision, which was which was you know initiated. First of all, it's the Kerala High Courts, and then it's the Supreme Court, which had uh, curbed the menace of that kind of strike or hartal or bandh, which are accompanied by violent by violent violent violence, or which are accompanied by violence. Uh, so here, all of us must welcome this kind of decisions, which had been remained a tool for creating headache for the government, for the nations, state government, for the or entire sometimes entire nations, because in case if such kind of bandh or hartal accompanied by violence are going to be encouraged, then every political parties or other social organizations which are associated on the name of religion, reason, caste, then they will be encouraged, and day and day repeatedly they will be creating nuisance for the citizen as well as for the government. Now, another decision which again related to call for or call given for a bandh and holding of a bandh in state of Tamil Nadu was dealt by was decided by, first of all it was the High Courts of Tamil Nadu, then later on it was our apex Supreme Court. Here the present petitioner filed a writ petition before the Madras High Court on 26th September 2007, making a prayer therein for declaration that the call given for a bandh and holding of a bandh in the state of Tamil Nadu either on 1st of October 2007 or any other date by the respondents 3 to 7, which are political parties uh, like your uh, Dravida Mununtra Kajagam, Indian National Congress, Communist Party of India Marxist, Communist Party of India, and you know that why the petitioners filed a writ petition, that it is the violation of fundamental rights under Article 19 and 21 of the Constitution, and besides, it is also the violation of the provisions under directive principles of state policy, and you know the fundamental duties also mentioned under the Article 51A of the Constitution of India. And the petitioner requested or made the interim prayer in the writ petition for restraining the respondents from proceeding with the call for bandh in the state of Tamil Nadu given by them on 1st of October 2007 or any other date in terms of resolution passed in the meeting held on 24th September 2007. And the said writ petition was placed before the divisional bench of High Courts, presided over by a learned Chief Justice of that court on 27th September 2007. On that day, undisputedly, a copy of writ petition together with interim petition was served upon the learned Advocate General of State of Tamil Nadu, who appeared in the court and submitted that call given by all these political parties, aforesaid political parties, was for strike or hartal, not for bandh. So it was further submitted that according to the judgments of this court, means the Supreme Court, the Communist Party of India versus Communist Party of India, Marxist versus Bharat Kumar of 1998, what is prohibited is called for bandh and its enforcement, but not for strike or hartal. So he then submitted that there was a distinction between call for bandh and call for hartal. So according to the learned Advocate General, as well as call was not given for bandh but strike, hartal. The judgment rendered by the court in Communist Party of India, Marxists, shall have no application as such. The writ petition was fit to be dismissed. Before the High Court, it appears that the copy of resolution dated uh, 24th September 2009 passed in the meeting of the aforesaid political parties, which was perhaps in Tamil Nadu, was produced and was officially translated, although the relevant portion translated version as quoted by the High Court in its order runs thus. In order to make understand the fact that the support of the people is only to implement the Setu Samudran project expeditiously to the central government, it is resolved to conduct a total session of work and closure of shops on the 1st of October and to conduct a general meeting of the leaders of the all parties on 30th day of September at Chennai. So before the court, it was pointed out that before the petitioner that the director of examinations had also postponed supplementary examination, which was to be concluded or which was to be conducted from 1st of October 2007 to uh, 4th October 2007. La University had also postponed the counseling, which was scheduled for 4th of October, etc. So, in the view of Band call given by the political parties, it was further pointed out that position would be peculiar as the Chief Minister himself, being the leader of the political party, respondent 3, had chaired the meeting and taken the decision, and therefore the call given was for statewide ban. So now after taking into the consideration the decision of the court referred above, means the after taking the consideration of the Communist Party of India versus Bharat Kumar, the uh, Madras High Court prima facie recorded a finding that the call given by the aforesaid political parties was for a bandh, not for a strike or hartal, claimed by them. So after recording this finding, the High Court admitted the writ petition and issued a rule returnable by 24th October 2007 and directed the case to be placed on the date at the. So while admitting the writ petition, the High Court had given following directions, that we issue the following direction to the first respondent, it is the Chief Secretary of Government, second respondent, Director General Police, then the all district collectors and other officers of the state, to ensure that no political party or organizations, association, group or individual can, by organizing bandh or hartal or by force or intimidation, stop or interfere with the road and rail traffic or free movement of the citizen in the state of Tamil Nadu on the date of bandh, that is 1st October 2007, to ensure that to take a appropriate action against the persons concerned in indulging the stoppage or interference with the road and rail traffic or free movement of the citizen in the state of Tamil Nadu. And the Chief Secretary of Government shall issue a press note to the print media and also to the electronic media on 29th September 2007 and 30th September 2007, informing about the preparation made by the police to deal with the bandh and to make a people secure. The meal, you know that the above, although all these directions were given by the high courts, and you know that it's the uh, it's the aforesaid orders passed by the high court on 28th, uh, the 28th September 2007, Friday, as on the petitioner was not satisfied, he was aggrieved by the aforesaid interim order, and it filed the present special leave petition under Article 136 of the Constitution. And all of you know that Article 136 is one confers a residuary power on the Supreme Court, conferred residuary power to the Supreme Court, that the Supreme Court, in case thinks fit in the given circumstances that aggrieved person the aggrieved person has not been dispensed with justice by the order or directions, by the interim order or directions or the final order of the any court. Any court means that including high courts and subordinate courts. Then the aggrieved party could move to the directly to the Supreme Court under special leave petition under Article 136 of the Constitution. And that's why, keeping in the mind the urgency of the matter, it was decided to constitute a bench on non-working day and hear the case in court 30th 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 September 2007 at 10:30 a.m. and that is how this case has been placed before us today, that it was quoted by the Supreme Court. It appears that the issue involved in the case was raised before the Honorable High Court of Kerala and full bench of that in versus uh, Bharat Kumar versus State of Kerala declared that giving of call for Bandh and its enforcement by any association or organization or political party was illegal and unconstitutional. And here the Supreme Court, you know, in its the relevant portion of the judgment of the High Courts in Bharat Kumar contained para number 7, 12, 13 and 17 and 18 were also quoted by the Supreme Court. And the Supreme Court uh, Supreme Court also uh, quoted that it is true that there is no legislative identification of expression, bandh, and such definition could not be tested in the crucible of constitutionality. But the Supreme Court asked, but does the absence of definition deprive the citizen of right to approach this court to seek a relief against the bandh if he is able to establish before the court that his fundamental rights are curtailed or destroyed by calling of such kind of bandh and holding of bandh when Article 19 Clause 1 of the Constitution guarantees the citizen the fundamental rights referred therein, and when Article 21 confers a right on any person, not necessarily the citizens, means not to be deprived his right to life and personal liberty, except according to the procedure established by law. Would it be proper for the court to throw up its hands in despair on the ground that, in the absence of any law curtailing such rights, so it cannot test the constitutionality of the action? We think not. So, when properly understood, the calling of bandh entails the restriction of the free movement of the citizens and his right to carry of his avocations under Article 19 Clause 1 Clause G. If the legislature does not make any law either prohibiting or curtailing it or regulating it, we think that it is the duty of the court to step in to protect the rights of the citizen so as to ensure that the freedoms available to him are not curtailed by any person or by any political parties. So, the way in this respect the courts have been shown by the Supreme Court in Bandhu Mukti Morcha versus Union of India also, where, because you know that once the Supreme Court found, as we discussed this case in the chapter of Bandhu Mukti Morcha, in the chapter of directive principles, and the relation of directive principles and fundamental rights, in which case, that the Supreme Court had found the glimpse of bonded laborers, then declared that it was the violation of Article 21 of the Constitution. So, in the light of that decision also, and it is also argued on the behalf of the respondents that a bandh could be peaceful or violent. Even if the court were to act, it could act only to the curtail violent bandhs and not peaceful ones. And it is contended that court cannot presume or generalize that the calling of bandh always entails actual violence or the threat of violence in not participating or not participating in the bandh. So the decision which was quoted by the Supreme Court, it was the Kameshwar Prasad versus the State of Bihar, the decision of 1962. For your kind information, dear students, don't get confused. We have got discussed the case law on the name of Kameshwar Singh versus State of Bihar. But now it is Kameshwar Prasad versus State of Bihar. And it's also referred in this contest. The theoretical aspects expounded by the counsel for the respondent does not appeal to us, especially since we understood in our country and certainly in our state, the calling for bandh is clearly difficult from a call for a general strike or hartal. We have already noticed that the call for a bandh holds out a warning to the citizen that if they were to go out for his work or to open his shop, he would be prevented and his attempt to take his vehicle on the road will also be dealt with. So it is true that theoretically it is for it is for the state to control any possible violence or to ensure that bandh is not accompanied by violence. So that it's the Supreme Court which also referred referred this decision. Uh, and the no political party organization can claim that it is entitled to paralyze the industry and commerce in entire state or nation, and is entitled to prevent the citizen not incentive with the viewpoint from exercising their fundamental rights or from performing their duties for their own benefit or for the benefit of the state or for the benefit of the nation. So such a claim would be unreasonable and could not be accepted as a legitimate exercise of fundamental rights by the political parties or those political parties or any kind of social organization. So the claim for relief by the petitioners in this original petition will have to be considered in this background. So the contention, another contention was raised by the political parties, the contention that no relief can be granted against the political parties in these proceedings under Article 226 of the Constitution cannot accept it in its entirety. So, as because that it cannot be accepted in entirety because the Supreme Court held that, as indicated already, this court has ample jurisdiction to grant a declaratory relief to the petitioners in all the presence of political party or respondents. So, this is all the more so since the case of the petitioner is based on their fundamental rights guaranteed by the Constitution. So, state has not taken any steps to control or regulate the bandh. So, the stand adopted by the Advocate General in this court cannot compel the state or the legislature to issue orders or make a law in that regard, as we find that organized bodies or associations or registered political parties, by their act of calling and holding bandh, trample upon the rights of the citizens of the country protected by the Constitution. So we are of the view that court has sufficient jurisdiction to declare the calling of Bandh and holding of it as unconstitutional, especially since it is undoubted that the holding of Bandhs are not in the interest of the nation, but tend to retard the progress of the nation by leading to national loss of production. So we cannot also ignore the destruction of public and private property when a band is enforced by the political parties or other organization. So we are inclined to the view that the political parties and the organization which call for such bands and enforce them are really liable, liable, uh, liable to compensate the government and the people, government and the public and the private citizens for the loss of the suffered by them for such destruction. So the state cannot shirk its responsibility of taking steps to recoup and recouping the loss from the sponsors of and the organizer of such month. So we think these aspects justify our intervention under Article 226 of the Constitution. So in view of the this discussion, we are allowed these original petitioners to extent of declaring that the calling for month by any association, organization, or political party, and the enforcing of that call by it is illegal and constitutional, unconstitutional. So we direct the state and its officials, including the law enforcement agencies, to do all that is necessary to give effect to this declaration. So here, uh, that it's the uh, Supreme Court in this landmark judgment after incorporating landmark case. All India AIMDMK Munitra Kajigam was the Chief Secretary, Government of Tamil Nadu, and others. So here the Supreme Court again we can say reiterated its approach. We can say that it's from the above we can say where perusal of the aforesaid decision in Communist Party of India means it would be clear neither can anybody give a call for month or can same be enforced. So the High Court in present case has recorded a prima facie finding that in present case the call was given for month, not for strike or hartal. So ordinarily the High Court as well as the court refrains from the passing interim order, the effect of which would be granting the main relief. But in cases where the party approaches the court without loss of time, there is no laches on its part. It is not possible to give notice to all the necessary parties and uh, hear them because of paucity of time. And in case interim order is not passed, in a case like the present one, which prima facie, in opinion of the court, is uh, concluded by the judgments of this court, the main case would become infectious. Different consideration would arise, and appropriate interim order should be passed. So, in the present case, apart from the state of Tamil Nadu, uh, out of out of the political parties, namely your DMK, INC, Indian National Congress, Communist Party of India, Marxist, Communist Party of India, etc., and that has appeared before us. We have heard at length. So, after making into consideration the entire matter, prima facie, we are also of the view that the call given by the aforesaid political parties is call for month, not for strike or hartal. So accordingly, we have no option but to issue notice to the non-appearing respondents and pass interim order, and that's why the Supreme Court until further order respondents number 3 to 2 restrained from proceedings with the call for one the state of Tamil Nadu on 1st of October, pursuant to the resolution dated 24th or any other day. So you know that voting, they were restraints. They were restraints to call for birth pursuant to the resolution dated 24th September 2007 or any other day. So it is again we can say the court or Supreme Court had propounded or had reiterated its approach propounded in uh, CPI Marxist versus Bharat Kumar 1998. Now another important uh, decision which relates to sorry which relates to another important case law that is again related to Article 19 of the Constitution. So far, we have discussed two important case law, and both case laws were interrelated to each other and interrelated to each other in context of the burning problems of Panth, calling of Panth. Now, I'm coming to another case law which was related to the reasonable restrictions or which was grounds of restrictions, and in the grounds of restrictions which are to be covered under Article 19 clause 2 contains the grounds on which restrictions on the freedom of speech and expression can be imposed. Here the one important ground, that is the sovereignty and integrity of India. This ground was added to the Constitution or was added to clause 2 of Article 19 of Constitution by 16th Constitutional Amendment in 1963. Under this clause, the freedom of speech and expression can be restricted so as not to permit to any one to challenge the integrity or sovereignty of India, as to preach cession of any parts of India from the Union. Now, there had been one offense which is to be covered under the heading of sedition. And students, we are going to discuss one landmark decision, that is the decision of Shreya Singhal versus Union of India. And I am going to uh, little bit discuss the little bit discussion related to the background of this case, and it relates to the sovereignty and integrity of India or public order. So here the sedition, the offense of sedition, as the offense of sedition was understood by the English law, and sedition embraces all those practices, whether by words or writings, which are calculated to disturb the tranquility of the state and lead ignorant persons to subvert the government. Means that to, in case if the ignorant people are going to teach and preach by the group of leading persons or the leaders to subvert the government or to undermine the power and authority of the government, that will the gist of that action or the gist of the offense of sedition, means that will amount it to sedition, and that is incitement of to violence, and mere criticism of government is not to be amounted to commit the offense of sedition. And in India, it's under Article 124, 124A of the Indian Penal Code, which declares as sedition whatever in words, by words, either by spoken or written, or by signs, or by visible representation, or otherwise brings or attempts to bring into the hatred or contempt or excite to um, excite or attempts for excite the disaffection disaffection toward the government established by law in India shall be punished, he shall be punished, and explanation to section 124 clause A states that mere commit of expressing disappropriation of the government is no offense if it does not excite or attempt to excite this disaffection toward the government or toward the government established by law. So the problem of sedition has been dealt by the courts time to time. Even this problem was dealt by the federal court in one case. It was the Niharendra versus Emperor. So the federal court held that mere criticism of, even ridicule of the government was no offense unless it was calculated to undermine the respect for the government in such a way as to make people cease to obey it and obey the law, so that only anarchy can follow. So the public disorder is the gist of offense, means that in case public disorder is going to be created by the incitement or by the way of uh, disaffection toward the government, then that will amount to commit the offense of sedition. And again, in 1954, that it is to be noted that the sedition is not mentioned in clause 2 of 19 of the constitution, uh, on which restrictions on such freedom of speech and expression may be imposed, but it has been held in uh, Devi Saran versus state that section 124A and section 153A of IPC imposed reasonable restriction in the interest of public order, and it is saved by Article 19, Clause 2 of the Constitution. And another case, it was the Kedarnath versus state of Bihar. The constitutional validity of the section of 124A IPC and was considered by the Supreme Court, and the court upheld the view taken by the federal court in Nihar Hendra case that the gist of the offense of sedition is that the words written or spoken have the tendency uh, or intention of the creating public disorder and held to be section of the constitutionality that will be valid. And now, in the present case, the restrictions which were imposed in the light of one latest, act, in the light of the Information Technology Act, and the restrictions to cover both within and outside permissible, means that the restrictions were within the permissible and outside the permissible scope or limits. So here in this case, Shreya Singhal versus Union of India, what happened? It was the section 66A and 69A of the Information Technology Act were challenged on the ground of uh, violating fundamental rights under Article 19, Clause 1, Clause A, and Article 14 of the Constitution. And it the Section 66A provides a punishments for sending offensive messages by any person by means of computer resource or a communication devices, etc. And it states that any information grossly offensive, menacing character, or any information knowingly to be false for the purpose of causing annoyance, inconvenience, danger, obstructions, insult, injury, criminal intimidation, enmity, hatred, or ill will, or persistently by making use of such computer resources or communication device or any electronic mail or electronic mail messages for the purpose of causing annoyance or inconvenience or to deceive or to mislead the addressee for uh, recipient about the origin of such message. Under 69A, the central government or any of its officers specially authorized by it in this behalf on being satisfied that it is necessary or expedient to do so in the interest of the sovereignty and integrity of India, or defense of India, or securing the security of India or the uh, state or the friendly relations or foreign states or public order or for preventing incitement or the preventing incitement to the commission of any cognizable offense relating to the uh, relating to the relating to the region to the section 12 for uh, for reasons to be recorded in writing. by order, direct or agency of the government or intermediary inter, eh, intermediary to block for access by the public or cause to the blocked for access by the public any information uh, generated or transmitted, received, stored, or posted in any computer resource. So uh, under section uh, under under subsection 2 of the procedure and safeguards subject to which such blockage for access by the public may be carried out shall be such as it may be prescribed. So under subsection 3, the intermediary who fails to comply with the directions issued under subsection 1 shall be punished with an imprisonment for term which may extend to 7 years and not uh, uh, and and shall also be liable to fine. So the contention of the government was that the 66A could be spotted under the heads of the public order or public order, defamation, incitement to an offense, decency, or morality, and the court filled mere annoyance need not cause disturbance of the public order. The court filled mere annoyance need not cause of the disturbance of public order. So the offense under 66A would be complete by sending a message either persistently, in case if the message is going to be sent persistently or otherwise without any manner impacting the public order, means that Supreme Court held that this provision is not going to be covered under the heading of public order. So the provision of 66A not aimed at a defamatory statements as as something may be grossly offensive or may annoy or be inconvenient to somebody without all affecting his reputation. 66A has also no proximate connection with incitement of the offense. Section 66A cannot precisely be said to create an offense which falls under the expression grossly offensive or, or annoying someone. So the word obscene is the conspicuous by its absence of section 66A. So under section 294 of IPC, the annoyance that is spoken of has to be caused by obscene utterance or acts and equality under equally under section 510 of IPC, the annoyance caused to any person must be by another person who is in the state of intoxication or who annoys a person in public place, which is a trespass for him to enter section 66 uh, is stark contrast, uses completely open-ended and undefined, vague language, and section 66 is cast too widely that virtue and opinion in which the subject would be covered by it is as any serious opinion is dissenting with the more of the day would caught within its net. So section 66 is unconstitutional. Also, on the ground that it takes within the sweep protected speech and is innocent in nature and is liable, therefore, to have a chilling effect, on Article 19, Clause 1, Clause A, and in a language wide enough to cover restrictions both uh, within and outside the constitutionality permissible permissible legislative action under Article 19, Clause 2. So, no part of section is severable because the Supreme Court here particularly mentioned that even the doctrine of severability cannot be applied. Why? Because the illegality are the illegality are so mixed together that even the doctrine of severability cannot be applied. And that's why, or hence, the section as a whole, 66A, section as a whole is unconstitutional. And the court did not agree that there was no intelligible differential. Means that the court, the internet as a compared to other medium of communication gives an individual a platform which requires very little or no payment to hear his views. Something posted on a site or website travels like a lightning and can reach millions of the people all over the world. And with regards to the section 69A, it was held to be constitutional and valid because the first and foremost, blocking can only be resorted to where the central government is satisfied that it's necessary to do so. So to do. So secondly, such necessity is uh, relatable only to some of the subjects sets out in Article 19, Clause 2. And thirdly, reasons have to be recorded in writing in such a block orders so that they may be assailed in a writ petition under Article 226 of the Constitution. So these rules further provide for hearing before committee, which took which looks into whether or not it is necessary to block the information. So this portion of IT Act was declared constitutional and valid, and it's all related to your this landmark decision, which has protected the vice right in Article 19, Clause 1, Clause A, which starts the freedom of speech and expression. So means that the communication under communication through the computer resources or uh, through other devices are subject to be protected in the light of article in the light of article 19 or article 69 clause A, means that all those are the because all those are subject to subject to cover the reasonable restriction. So it's all for today's lecture. I would continue in my next lecture. So thank you.